be addressed in the short term. I'm further concerned to hear that there's going to be cell facilities now provided at the courthouse, because while that may solve some of the security issues, it does not solve the issue. The core issue, the substantive issue, is the relocation. It's a pity if the court services need assistance in securing and sourcing a suitable site. I know that many of the local businesses and many of the local stakeholders would be more than glad to help them in that regard. And while I realise that resources are limited, I think this would have to be revisited as a priority. It cannot happen that we could continue to have a court sitting virtually every day of the week now in Portlaoise on the main street. And to finally say, Cathaoirleach, that it mesmerises me in the extreme that the previous government spent 30 million on securing a Thornton Hall site for a prison that is never going to be built. And we'd have located and bought umpteen sites in Portlaoise for a new courthouse for that money that was essentially squandered down the drain on behalf of the taxpayer. And Minister, I would like you to impress upon the Minister for Justice our ongoing concern in this matter. Thank you.
Julian stated that the government is certainly conscious, Senator, of the value of providing for an excellent court system, and has continued to provide substantial resources to the service, with a supplementary estimate of 5 million provided last year on top of the original net budget of 54.1 million. However, I know the Senator will appreciate that no area is exempt from the financial constraints of the past years. In relation to some court rotations, the Board has had to take unpalatable decisions to close a number of smaller, non-viable venues, and certainly has had to introduce more efficient work processes to allow the service to continue to provide frontline services with the reduced staffing levels that are essential nowadays. The service has stated that it will certainly keep the issue of Portlaoise Courthouse under review, and obviously the fact that with the meaningful dialogue with the court service over a period, and without doubt they're very conscious of the need that you have stated.
Okay, thanks very much, Minister. Now could we have Senator Jillian van Turnhout, please?
Welcome, Minister. I'm aware that an informal meeting of Ministers for Justice and Home Affairs will be taking place at the end of next week in Vilnius, and I understand that the General Data Protection Regulation is on its agenda. Minister, I've been contacted by a number of people in the genealogical community who are concerned that the European Commission plans to unify data protection within the European Union with a single law, that is the General Data Protection Regulation, may have unintended consequences. I've specifically been contacted by Michael Merrigan, General Secretary of the Genealogical Society of Ireland, who in turn has been contacted by the Genealogical Society of Finland, and I'd like to thank them for the information that they have provided me. I have a keen interest in researching my family history, and I have first-hand experience of accessing resources through my research. And I realise the sensitivity of some data, and so understand that we do need to protect privacy. Minister, we've all welcomed the renewed focus on genealogy due to the events surrounding the gathering, and in addition, the Government has proactively engaged in the provision of online access to genealogical resources through the national repositories and its genealogical web portal, irishgenealogy.ie. And, for example, Minister, I'm also very aware of the sheer dedication and work by genealogists such as Stuart Rosenblatt, who has provided the state with an invaluable 16-volume archive spanning over 4 centuries. And I think he, for example, is a guiding example to us all. The recent report published by the Joint Oireachtas Committee on Finance, Public Expenditure and Reform with regards to its hearings in relation to the draft General Scheme of the Freedom of Information Bill highlights the need to seek the inclusion in the proposed legislation of the following as guiding principle by which record holders, that is the state and state agencies, would give public access to records with a genealogical potential by the inclusion of a section that states that the legislation endorses and fully supports the principle of public ownership and right of access of our genealogical heritage. By doing it in this way, it will allow statutory instruments and departmental guidelines to take cognizance of the principle when accessing public accessibility to records with a genealogical potential. And so to my question for you today. I'm very cognizant that an EU regulation must be observed by all Member States. The impact of the inclusion of civil registration records in the scope of Data Protection Directive, if that is what is actually proposed, would have a detrimental impact on genealogical, biographical and historical research. While such a measure would have no impact on the existing public access to genealogical resources held by our wonderful National Library and equally wonderful National Archives of Ireland, it could create an atmosphere of fear of litigation on the part of custodians of records of genealogical potential. So, Minister, what I'm asking is, can you ensure that the revised EU data protection regulation does not impair the right of the citizen to engage in bona fide genealogical, biographical or historical research, and that the principle of public ownership and right of access to our genealogical heritage will be enshrined as a guiding principle? I believe that genealogy should be expressly mentioned in the regulation and hope that you can give us the assurances today. On a specific point, Minister, within the regulation, Article 6, Paragraph 2 should be rewritten so that it makes an exception from the general principle for processing of personal data, that is, that a subject has been given consent to the processing. As a result of this, it would not be necessary to request consent to processing of personal data when the purpose is historical research or genealogy. And I hope, Minister, that we can get your assurances today and that the access to genealogical, biographical or historical records will not be impaired and that we will be able to ensure public access for generations to come.
Okay, Minister.
Mr. Hewitt, I'm standing in for my colleague, the Minister for Justice and Equality, who was unavailable to hear this evening. At the outset, I want to thank the Senator van Turnhout for raising this important subject. I'd like to take the opportunity to briefly set out the background to the European Commission's proposal for reform of data protection law. The centrepiece of existing EU legislation on personal data protection is Directive 95/46/EC, which seeks to reconcile the protection of personal data with the free flow of such data within the internal market and to countries outside the EU. It is widely recognised that the 1995 directive needs to be updated, which I think is important to note, to take account of more recent developments such as increased use of the internet, blogs and social networking sites, and the increasing globalisation of data transfers. In 2010, the Lisbon Treaty introduced a new legal basis for strengthened data protection standards in the European Union, and Article 8 of the Charter of the Fundamental Rights of the EU enshrines the protection of personal data as a fundamental right. In January 2012, following completion of an extensive consultation process, the European Commission tabled proposals for a radical shake-up of the current regulatory framework. And these proposals are currently being discussed separately in the Council of the European Union and the European Parliament. Adoption of the reform package is subject to a co-decision between both institutions. Article 5 of the Commission proposal for a general data protection regulation, which sets out the principles relating to personal data processing, recognises that it may be necessary to retain personal data for historical, statistical or scientific purposes. Furthermore, Article 83 sets out specific provisions for processing of personal data for historic, statistical and scientific research purposes. While the Minister has until now not been made aware of the specific concerns of the genealogical sector, he is aware that concerns have been raised that the provision of the Commission's proposals are not sufficient to accommodate the processing of personal data for historical, statistical, scientific or archival purposes. The Minister shares those concerns. As the Senator may be aware, achieving progress on the European Commission's proposals to update the Union's data protection standards was a priority of the Irish Presidency, and I am pleased to say that a substantial progress was achieved on key aspects of the reform package. The Minister submitted a progress report on the June Justice and Home Affairs Council, which identified key aspects of Chapters 1 and Chapter 4 of the draft regulation. And in addition, a draft revised text of Chapter 1 to Chapter 4, which reflects the Minister's view as then President of the GHA Council of the state of play of the negotiations at that stage. The Minister has arranged to have these documents laid before the Houses for information of deputies and senators, which will be very important. The draft revised text concludes a number of proposals which have yet to be discussed in detail at expert level to address concerns in relation to the implications of the draft regulations for the processing of personal data for historical, statistical or scientific purposes. It is understood that it is intended to discuss this issue at the expert level shortly. And the detailed discussions of these proposals will also afford an opportunity to consider whether proposals to deal with the processing of personal data for historical, statistical or scientific research are sufficient to cover archival purposes as well as bona fide genealogical and biographical research, or whether specific provisions are necessary. So in conclusion, the Minister believes that the concerns in relation to the implications of the draft regulation for historical, statistical, scientific or archival purposes, including the bona fide genealogical, biographical purposes, need to be examined further at expert level in the Council Working Party on Data Protection and Exchange of Information, the DAPIK, and addressed where necessary by means of appropriate amendments to the regulation.
Okay, thanks very much, Minister. Now,
just very briefly, firstly, Minister, if we could get a copy of the script, traditionally we do, and if it would be available, it would be very useful for us just to be able to look at. Secondly, I thank you for the assurances, and I just to reiterate the importance, I think, of specifically mentioning genealogy, so that we will ensure that there is public access to these records when it's for a bona fide purpose. So I certainly will correspond with the Minister for Justice on this issue, because I think it's important in that lens is also looked with the General Data Protection Regulation. Thank you.
In conclusion, just an overview, Deputy Minister wrap up. The European Commission tabled proposals for a radical shake-up the current data protection framework. I'm very happy to give you the copy of this text as well. The data protection reform proposals are undoubtedly one of the most important reform packages being discussed at EU level at present. Data protection affects all of us, whether in private capacity or as individuals, or in business or professional capacity, or as users of personal data. It was for that reason that the Minister for Justice and Equality launched a public consultation process in March 2012, seeking the views and inputs of interested bodies and individuals on the proposed regulation in order to inform the negotiations on the proposal. The Minister continues to welcome views and inputs on the implications of the draft regulation, as discussions on this detailed and complex proposal are still ongoing at the European level. And in particular, the Minister would welcome views, which would your own views indeed, and inputs on the specific concerns that may exist in relation to the implications of the draft regulation for bona fide genealogical, biographical or historical research. And in conclusion, as I said earlier, that the protection of personal data is a fundamental right. However, the right to the protection of personal data coexists with other rights, which is recognised as the draft regulation. For example, Article 83 of the draft regulation sets out specific provisions for processing of personal data for historic, statistical and scientific research. And the Minister believes that the implications of the draft regulation need to be examined further to assess the implications of the proposed for historical, statistical, scientific or archival purposes. And the Minister would therefore welcome views on any specific amendments to the draft regulation that are considered necessary to accommodate bona fide genealogical, biographical or historical, but take account of the need to provide high levels of data protection to individuals. And once again, I would like to thank the Senator van Turnhout on behalf of the Minister for raising this important issue here this evening. Thank you, Senator.
We will pass that on to the Genealogical Society of Ireland and the wider genealogical community. Thank you, Minister.
Thank you, Minister. Thank you, Senator. Now, could we have Senator Dennis Landy, please?
I'd like to welcome the Minister of the House also this evening. I'd also like to welcome Councillor Brian Collins in the Visitors Gallery from Kells. Councillor Collins is one of the driving forces for the campaign for VAT reform. And Minister, while I welcome you to the House this evening, I know that it's an area that you're very familiar with as a businessman yourself, the various VAT rates that accrue across various services and goods in this country. There needs to be a comprehensive review of the VAT system in this country. One has not been carried out, and what has happened is that VAT rates have evolved over time. Some are in existence pre our entry to the EU, and some have occurred as a result of new services and new goods being made available. It is something that has not been discussed by previous governments, or indeed to any great extent by this government, except for the fact that the VAT on tourism products and tourism itself has been reduced, and it has been proven that this has been of great assistance in the tourism industry in this country. The tourist lobby in this country has been very strong in ensuring that it's reduced, and they have proved that what they have asked for has actually borne fruit. Tourism the first 6 months of this year was up almost 20%. Some of it as a result of the gathering initiative, but certainly a lot of it as a result of the value for money that's in this country at the moment. If I just give a few examples of the ludicrous situation that we have with VAT at the moment. Fruit juice is 23%. Frozen pizzas is at 0%. A walking stick is at 23%. The hire of a limousine is at 0%. So, Minister, you will clearly see that there is no assimilation between the services that are needed and the system that we have in place at the moment. There are great opportunities in job creation by a review of the whole VAT system.